My Lords, before the break, I was in the Jacobs judgment, Lord Justice Morbick. I was going to go back to that briefly for two points. The first is just to draw your Lordship's attention. So it's in Bundle 3 at tab 38. Just going to draw your Lordship's attention briefly to the paragraphs which set out the scheme as Lord Justice Morbick sees it. And we agree with all but one small point on that. Small but significant. The first two paragraphs are 11 and 12. I won't go to in detail, just so your Lordships can mark that, because there he's setting out his approach to the scheme. But the main paragraphs, that's 11 and 12, the main paragraphs are 21 and 23. And I was going to go specifically, so it's 11 and 12, but then I was going to draw your Lordship's attention particularly to 21, and then the end of 23. So...
All right, shall we just read it to ourselves?
Indeed, Lord. And it's from C on 23. The central concept.
Yes.
So, and the only point it's the end of 21, the fourth point that is made in that paragraph. So, safety net doesn't ultimately bear the burden of the compensation scheme, compensation body, and the assumption that which your Lordship's already referred to, Lord Vance. But the fourth directive does not go so far as to provide that such questions are to be determined by reference to the law of the country in which the accident occurred.
We challenge that because you say the reference back to Article 1 of the second directive brings in the quantification.
Indeed, my Lord. Yes. And then at the end of 23, the central concept provides easy access to a defendant's own country, while ensuring that liability ultimately comes to rest with the person or body with whom it ought to reside. Moreover, the scheme does not detract from the claimant's rights against the driver himself or against the driver's insurer. We would add in there, or against the foreign guarantee fund for the place of the accident. Because Article 7 specifically refers to the guarantee fund. So the relevant entitlement, we say in Article 7, is that against the second directive guarantee fund, not that against the tortfeasor. And there can be minor differences. Well, maybe not so minor, but there can be differences. And he acknowledges the anomaly in the end of that paragraph. So that's the scheme.
You say against the foreign guarantee fund.
That's incorporated by the in accordance with. So the words in accordance with the second directive body.
But that's a claim against not the foreign compensation fund. That's a claim against the compensation fund in the member states where you reside, isn't it?
That's the compensation body, my Lord. Yes.
But what are you referring to here?
It's the words in accordance with the provisions of Article 1 of the Second Motor Insurance Directive. That's not referring to anything against the compensation body. That's referring to a claim which the claimant has against, in this case, the Greek guarantee fund.
Yes, so you'd add that central concept.
Yes, Lord.
That's under the second directive.
Indeed, my Lord, yes.
Yeah. Right.
And then Lord Justice Morbick comes on to deal with the point on Rome 2. So following Rome 2, he essentially finds that Rome 2 is not applicable. He finds it applicable to the liability of the driver, but it has no impact on compensation. And the way in which he does this is apparent from 35 and 38 of the judgment. It's in 38, he says that the parties agreed, that's about just below D, the parties agreed that Regulation 13.2b is not a choice of law clause, and they agreed rightly because it's concerned with defining the existence and extent of the obligations of the body appointed, rather than determining the liability of the wrongdoer. But earlier, in paragraph 35, he said the words I've already drawn your lordship's attention to, just above, between F and G. He says that, well, there are no limiting words in as if the accident has occurred in Great Britain. So in the absence of any provision limiting its scope, I don't see why, it's difficult to see why it should not also affect the principles governing the assessment of damages. And so he concludes in 37 that the language of 13.2b requires him to conclude that compensation is to be assessed on the fictional basis that the accident occurred in Great Britain. So the effect of the construction, we say, this construction in those 3 paragraphs, is that as if the accident occurred in Great Britain, is operating as a choice of law clause. And we say that because effectively what the words are saying, the fiction that the accident occurred in Great Britain, is essentially manipulation of the connecting factor. But the place of the accident is the key connecting factor. In accident cases, it tends to be the most important connecting factor. And a combination of Articles 4 and 15c of Rome 2 requires the court to disapply such a device, whatever its label and however it operates. I mean, in a sense, there's a similarity, without going to it. There's a case called MSG against Javier Renan. It's 5/62 in the bundles, but that was a case where jurisdiction in contract, as we know under Brussels 1, depends on the place of performance of the relevant obligation. And the CJU in that MSG case had no hesitation in rejecting a deemed place of performance. So deem the place of performance to be, I don't know, was it Rotterdam? Germany, when in fact the place of performance of the obligation was in France. And this interpretation of Lord Justice Moore-Bick, in a sense, it manipulates the applicable law, but it does so only in relation to the law applicable to the assessment of damages. And we know from 15c, perhaps I should have gone to that at some stage, it's in Bundle 1 in Rome 2 at tab 7. 15c says that the applicable law, which Lord Justice Moore-Bick agreed that the liability of the driver was to be decided by the law applicable under Rome 2, but the applicable law in 15c on page 398, so volume 1, tab 7, page 398, governs, see the top of page 398, top right, the existence, nature, and assessment of damage or the remedy claimed. It's that which reverses Harding and Whelan's for the UK. And the idea, as Lord Justice Moore-Bick, higher up in the judgment, paragraph 33, he'd relied on the principle in Macmillan, the English conflict of laws principle, whereby a different law may be applicable to different parts of the cause of action. Different issues may be governed by different laws. But Article 15 of Rome 2 makes clear in our submission that the applicable law governs all issues, including liability and assessment, subject only to issues of procedure and evidence. And that procedure and evidence is 1.3. So we say that the Rome 2 case obviously is an alternative to our primary case as a matter of the scheme, but we say at the very least after Rome 2, if the regulations impose a liability for what is effectively the driver's liability, if I assume I've lost on my scheme point, then the law applicable to the driver's liability and compensation would normally lead to the law of the country in which the accident occurred. At all events, the relevant applicable law would apply not only to liability, but also to compensation.
Well, how do you get into Rome 2? Parties can contract for anything they like, and presumably the government can legislate, leaving aside European Union law, for anything it likes in this context. It could, let's assume there was no European law, the government could set up a body which was responsible for compensating victims of motor insurance accidents across Europe, across the world, and provide that it should do so in accordance with the law of the UK. would there be anything, Rome 2 wouldn't have any application then, would it?
Well, with respect, my Lord, it would, because the Rome 2, it's a regulation. It's directly applicable.
No, but you've got to find it. You've got to find. Surely we only get into Rome 2 if you treat the liability of the compensation body as effectively an insurance liability in respect of the liability of the negligent driver. If you do that, then I can see that the primary liability is the negligent drivers. That's subject to Rome 2, and the insurer is only picking up the tab of the negligent driver. But is Regulation 12? I mean, I know you say sort of indirectly it's rather similar, but is it? Can it be categorised in the same way? Or could it not be said to be something sui generis and rather similar to a contractual obligation, or here a public law obligation imposed by the legislator?
I mean, we would say not, my Lord, because the...
I mean, you accept, don't you, that it would be perfectly open for me to contract with someone to reimburse them or to indemnify them in respect of liability, injuries sustained in Greece by the negligence of Greek drivers, according to English law principles. I could make such a contract, couldn't I?
Yes, I mean, Article 14, of course, does restrict the freedom of choice in a Rome 2 context. It's supposed to be a code which applies to non-contractual obligations. So,
But which is the non-contractual obligation? It is of the negligent driver, is it, that you're focusing on?
I am, Lord, yes.
So you get into Rome 2 by saying that we're primarily concerned with the entitlement of the injured party against the negligent driver, and this is something which ineluctably must be viewed according to the provisions according to the law determined under Rome 2.
Yes, and it's the
Does that mean that ineluctably the liability of some third party, the unfortunate compensating body, has to be determined in accordance with the same principles?
It does, my Lord, because inevitably, if it's a foreign accident, I mean, for English accidents, that's perfectly fine.
Yeah.
But for foreign accidents, it's Article 1.1. This regulation shall apply in situations involving a conflict of laws to non-contractual obligations in civil matters. That is, the words somewhat, we put in...
I mean, the argument against you is that Regulation 12 isn't purporting to alter the tortious liability of the negligent driver at all. It's just not dealing with that. All it's dealing with is the amount which the compensating body has to pay to the injured party.
But in doing so, it's trying to implement Article 6. And I know Article 6 Article 6 is distinct from Article 7, and it's a totally different sort of liability, we say, because it's the compensation body is doing a wholly different job. But...
Sorry, Article... Yeah. Yes, I see. Sorry, I see. I'm talking about Regulation 12. Perhaps I should have been talking about Regulation 13. Yes. Same points apply, I think. I can see under Article 12 you've got a stronger argument for saying that is an insurance-type liability, but I was simply exploring the proposition. I should have been referring to Regulation 13, exploring the proposition that there wasn't necessarily a proper law of the tort point here at all.
Well,
because no one is denying that the injured party can recover from the guilty party in accordance with Greek law only under Rome 2. The question is, what is the entitlement to compensation against the compensation body?
of course, the entitlement which we focus on for Article 13, for Regulation 13, is the entitlement against the guarantee fund at the place of the accident.
Yeah.
And the the scope of Rome 2 is in any situation involving a choice between laws of different countries. In a sense, to avoid that choice by the way in which you frame matters in domestic legislation for a foreign, in respect to a foreign accident, we say that it can't sidestep the Rome 2 because of those opening words of the fourth directive, the entitled to compensation. What's your entitlement? You've got to go back to the nature of the entitlement. Yes, I suppose in a way, under the direct right of action, member states might be tempted to say, well, you get a direct right of action and you'll always get English damages. But of course, they can't say that, for the reasons I've submitted.
No, I mean, if it's an insurance situation, if you were talking about the liability of the Greek body or motor insurance bureau or whatever, you would be certainly talking about a liability in respect of a tortious liability, and that would be necessarily, the two would necessarily be the same.
And the other basis on which Learned Friend says that we are not within Rome 2 is it's not civil and commercial. And he cites cases involving public bodies, waging war by armed forces, removing wrecks in waterways pursuant to treaty, submitting a bill for air traffic services provided pursuant to a treaty, issuing bonds on financial markets. And there's just one case I'd like to refer your lordships to in the supplemental bundle, the case of Henkel in the supplemental bundle at tab 75. And it's 2 paragraphs in Henkel. Henkel concerned a consumer protection organisation which took claims against traders who had unfair contract terms, or in the view of the consumer protection organisation, which had unfair contract terms in their contracts. And so it clearly had a public interest function. But at page 43 on the supplemental member stick, 26 and 30, if I can read just 2 paragraphs, paragraphs 26 and paragraph 30, the court at 26 refers to the cases cited by my friend against me. It is settled law that actions between a public authority and a person governed by private law fall outside the scope of the Brussels Convention only insofar as that authority is acting in the exercise of public powers. That's the key phrase, exercise of public powers. And the consumer protection organisation in this case certainly had a public interest function, at the very least. But 30, not only is a consumer protection organisation such as VKI a private body, but in addition, as the German government correctly observed, the subject matter of the main proceedings is not an exercise of public powers, since those proceedings do not in any way concern the exercise of powers derogating from the rules of law applicable to relations between private individuals. On the contrary, the action pending before the National Court concerns the prohibition on traders using unfair terms in their contracts with consumers, thus seeks to make relationships governed by private law subject to review by the courts. An action of that kind is a civil matter within the meaning of the first paragraph of Article 1. And here, in this case, your Lordship put to me a moment ago, MIB is effectively, on my alternative case, acting as an insurer.
But except it's not, in fact, is it? It may well be acting in a way that an insurer would act, but it is acting under public law powers, isn't it?
Well, it's certainly got a function which looks public, but public law powers?
Well, it's certainly exercising a public law function.
It is, Lord, yes.
And, I mean, it's difficult to see how choice of law comes into such an exercise. You've just got to construe the function as described in the instrument which creates it.
Well, I mean,
There are a number of public schemes for effectively acting like a reinsurer, but on a completely different juridical basis. The public scheme about indemnity for terrorism and so on. And they all operate, don't they, as a matter of public law. They're not contractual. The fact that the result might be very similar if they were doesn't matter, because what one's looking at is the juridical origin of the function they're performing.
but I mean, perhaps in this context, my learned friend cites Farrell and Whitty, an Irish case involving the Irish the equivalent to the MIB, and the question in that case was whether an emanation of whether the MIB was the Irish MIB is an emanation of the state, and there it distinguishes between the public function, certainly we have here, and the exercise of public power. And the exercise of public power in the other cases was waging war, removing wrecks, billing for air traffic services, providing something which is required as a matter of public obligation. But in Farrell and Whitty, again, the supplemental bundle, at the question sent for reference by the Supreme Court, it's in supplemental bundle tab 76. Distinguishes in the questions posed, it's the third question, is it sufficient that a broad measure of responsibility has been transferred to a body by a member state for the ostensible purpose of meeting obligations under European law for that body to be an emanation of the member state? Or is it necessary, in addition, that such body additionally have special powers, operate under direct control or supervision of the member state? So it's got
The issue here was whether it was an emanation of the state.
Indeed.
Is that really comparable to the issue which we have?
Well, in a sense, it looks closer to the state. I mean, learned friends citing it against me, but to be an emanation of the state, well, no, I mean, you're just right. I mean, it is a different test.
So which was the bit you were citing from Farrell?
Just on page 61, at the end of...
Oh, yes. Yeah, that's it.
The third question.
Back of 3.
This is a question asked of the court in Europe at some future dates.
This is, I think it was argued last week, if I remember correctly, in the Court of Justice. And I should have gone to the beginning, in the sense is the Foster and British gas test, where on the basis that the elements of the test are to be applied conjunctively or disjunctively. And, I mean, of course, in Henkel, the body was providing, was focusing on whether it was a public power, certainly was some degree of public function, but that doesn't seem to be sufficient for it to be not to be regarded as civil and commercial.
Well, it may turn on the answer to this reference.
Well, my Lord, I think the emanation of the state test is different. I was simply drawing that out. My learned friend cited against me. I say it's a different test.
If it's not an emanation of the state, it may still be, as my lord was putting it, exercising a public function.
If it is an emanation of the state, then it almost certainly is exercising a public function. But the converse surely is not true. You can have a body which unquestionably is not an emanation of the state, but nonetheless is exercising a statutory power or a statutory duty. And you just have to construe the instrument which creates the power or duty in order to discover by what law it is supposed to do it. It's not really a question of choice of law, which is an inherently private law concept.
Yes. I mean certainly that becomes more difficult to sustain, Lord, in relation to Regulation 12, which has what seems to be an express choice of the relevant part of the United Kingdom.
Do we get any assistance from State of Norway's application?
State of Norway's application.
Assistance on this from State of Norway's application, which deals in general terms with the meaning of civil and commercial matters?
Lord, I shall look at that.
I mean, It's a long time since I've read it, and maybe a complete red herring.
But we'll look at it, Lord. I'm sorry I hadn't looked at that in advance. And just...
You're practically at the end of...
Yes, my Lord. I'd say, well, I'll leave 4.2 and 4.3 for reply. I'll just say brief words on possible reference. Our case clearly depends on the proper interpretation of the directives. This case raises issues which have clear ramifications across all EU member states. And insofar as on my primary case, the CJU is best placed to rule on the meaning and effect of Article 7 of the Fourth Directive. And if we're right on our case on the scheme, then the English court would strive to interpret the English regulations in accordance with the ruling of the CJU. If we're wrong, we lose. But that's, as must be the case. Because we can't establish our case. What I'm saying is we can't establish our case from the regulations. We must establish our case from the directive.
I'll just ask you an elementary question about the regulations 2003. Article 2, Regulation 2, definition of compensation body, is that a simple typo? Yes, it's coming from the other side of the court, right? Because it's Regulation 10, not Regulation 9.
Sorry, what regulation?
Indeed.
Where is this?
In
Regulation 9.
2 of the 2003 regulations, definite interpretation, compensation body means the body named in Regulation 9, typo for 10, because 9 has nothing on the point.
Yes, Lord, indeed. And there's one definition which has been removed. But I'm relieved it was an easy question, because often in the Supreme Court, when somebody says it's an easy question...
The other thing is, when you
be.
come to Regulation 13(2)(b),
Yeah.
as if it were the body authorised under paragraph 4 of that article, I'm right in understanding that it is the body article. There might be the body identified in 10 is the body authorised under paragraph 4.
But it's quay, it's doing a different job.
It's a queer, odd language.
Yes,
It's
but
hypothetical, but it is. I mean, second directive requires the member state to authorise a body. If I understand it rightly, the MIB has been so authorised.
It has, my Lord, but...
When it expresses it as if it were the body authorised, well, it is. You've got to read, I suppose, the whole thing as a phrase. You say, meaning, really, as if this were an article, as if this were a second directive type of case.
well, with respect, not, my Lord, because we distinguish between in accordance with the provisions of Article 1 of the Second Motor Insurance Directive. From that, we get the compensation would be that provided by the Foreign Guarantee Fund, but then as if the accident occurred in England is the first, the Great Britain, that's the first fiction. And the second fiction, as if the compensation body were the body authorised, it's giving it, because these regulations don't give the compensation body a task qua guarantee fund. That is given by the relevant agreements. Yeah. And so I think those words are made necessary, and I think that's what Lord Justice Moore-Vick explains, by the agreements.
Okay, thank you very much.
And also, I mean, Motor Insurers Bureau and compensation bodies could be completely different bodies.
Absolutely, my Lord. Yes,
Yeah.
in Spain, the Bureau, the compensation body, and the guarantee fund are three separate bodies. Lords, unless I can assist your Lordships further at this stage, those are our submissions.
No, thank you very much indeed. Ms. Kinsler? Thank you. Mr. Beard?
My Lords. Now, Mr. Mercer has conjured up a picture of a system where compensation bodies created to provide access to compensation for victims of accidents in a foreign state, and where that compensation is to be provided under the terms of that foreign state's guarantee funds rules. And then the compensation body here in the UK, for example, would be able to claim against the foreign guarantee fund. And so the foreign guarantee fund, the place where the accident occurred, is the ultimate debtor. And he says this is a very smooth scheme, and that if, as per our case, you allow the UK scheme under the regulations to operate such that the UK compensation board is paying out at a UK level of compensation, that undermines the smooth scheme, and the Greek guarantee fund, as it would be in this case, would end up reimbursing the UK at UK levels of compensation, and that would be requiring it to lump it.
I'm not sure he does say that. I think he says there'll be a discontinuity at the UK level. It'll end up being borne by UK insurers.
Well, I think...
Not because, he says, the Greeks would be able to say you've applied the wrong law, and that's
Yeah.
one of the,
Under
that's
the-
the let-out clause.
Well,
Under the agreement.
He says that, but he also says that where if our case were right, then the reimbursement mechanism that would be called upon against the Greek guarantee fund would be asking for recompense at a UK level, which would be...
Well, I mean, do you accept that, as the Court of Appeal, I think, more or less accepted, that one way or the other there's an anomaly? Either analysis is anomalous.
There is the potential for some lumping it somewhere down the line, yes. So if that account amounts to an anomaly, in the sense that a Greek guarantee fund could end up reimbursing a UK compensation body at a UK level rather than at a Greek compensation level, then yes, that anomaly.
But there are anomalies there are further anomalies, because on your analysis, you could end up giving UK damages when against a compensation body, when in fact damages according to the law of the place of the accident would have been higher.
We would provide them at a UK level. Undoubtedly, that's right. That is the way that we say that the scheme is intended to operate, because it is a scheme that's intended to facilitate a person who's in a difficult position.
Yes, but just answer my question.
That must be right in relation to the claim against the compensation body. If that person wanted to pursue claims overseas...
So you'd have to do it twice.
They'd have to do it separately, yes.
Well, that doesn't seem consistent with the declared object of this scheme.
But there would be there'd be alternatives in those circumstances. They couldn't be. The reason why the UK scheme is set up as it is to ensure that the body that exists, the guarantee fund, that does make payments to claimants of accidents involving uninsured or unidentified drivers under UK quantum rules, does the same thing in relation to accidents that occur overseas involving UK residents, and it is effectively facilitating those UK residents being able to bring claims more quickly and more easily. And that, of course, is the overall purpose of this element of the Fourth Motor Insurance Directive. So, to that extent, one does accept that there must be potentials for anomalies, but we say that the UK regulations which have put this in place are consistent with the scheme of the European directives. More than that, we say that that is the proper interpretation of the European directives, that this is the appropriate way of dealing with matters. And it is worth emphasising that Mr. Mercer has to put his case high, that effectively the directives mandate the alternative system, and in effect the domestic regulations, such as they are, should be read down to such an extent as we would say is beyond the scope of Mar leasing interpretation, and indeed are effectively seeking to disapply them. Mr. Mercer, and I will go back through some of the European material, has talked a lot about in the European scheme the need for compensation to be provided by the compensation body. We entirely accept that, but as my Lord Clerk picked up earlier in a point raised with Mr. Mercer, nowhere in that material does it specify the level of that compensation. Second point to note is that, as I've indicated, there are a range of reasons why the UK regulations are as they are in relation to compensation bodies, so as to enable and facilitate the ease with which a person who has suffered a potentially very serious accident by reason of an uninsured or unidentified driver overseas is able to get recompense more quickly through an organ in its own state, which is used to dealing with quantification of damages under English principles of quantification. And the third thing that I will come on to is that although one refers to the possibilities of anomalies, the possibility of one compensation body having to lump reimbursement at a level to another compensation body or guarantee fund higher than that which they would pay out under their own rules, what we actually see in relation to Article 7 is that that degree of lumping it actually does occur even on, or a significant degree of lumping it occurs on Mr. Mercer's own account in relation to Article 7 and his interpretation of Article 1.4 of the second Motor Insurance Directive. So with those introductory remarks, if I could just go back to one or two of the EU law provisions, and it perhaps is most useful just to start back in one or two of the elements of the travaux préparatoires, which are found in Authorities Volume 1, Tab 11, beginning at MS 478. And if we could just pick it up at page 480, there we see the description of the purpose of the proposal that is being presented by the Commission for what later became the Fourth Motor Insurance Directive. And what we see, and I just asked the court to read that paragraph through to the content of the directive, is the sense of trying to facilitate claims and compensation where difficulties arise due to dilatory insurers or the lack of identification. If we could just move through, one sees in this proposal at page 488 a reference to the creation of compensation bodies under what was then Article 5. But if we go over to the page to 490, we'll see what later becomes Article 7, but is then Article 6, cases where insurer cannot be identified being described. The insurer proves impossible to identify, the system set up, so that's direct right of action, claims representative, compensation body can't operate. The objective of this article is therefore to ensure that although one of the conditions for the operation of the arrangements established by the directive is not fulfilled, the victim will in any event be compensated. In this case, the guarantee fund in the member state where the victim resides will be responsible for compensating the victim. Subsequently, when that guarantee fund applies, the guarantee fund in the member state where the vehicle is normally based will have ultimate liability. And then it goes on under Article 1.4 of the directive, read in conjunction with 3.1 of the first Motor Insurance Directive. It's the member state where the vehicle is normally based that's responsible for ensuring that each vehicle is required to have civil liability insurance. It follows that if a vehicle is not fulfilling that condition causes an accident, it's the guarantee fund of the member state where that vehicle is normally based that's liable for the cost of compensating. And then the reasoning behind this article is in line with that of Article 5 of the proposed directive, a victim of an accident occurring outside his state of residence has an interest in securing compensation on the same conditions as those applicable to the function of the compensation body provided for in Article 5 in his state of residence. Thereafter, the guarantee fund of the victim's state of residence has a claim against the guarantee fund of the state where the vehicle causing the accident is normally based on the same conditions as those laid down in 5.2, subrogation of the victim rights, and so on, and by reference to that article. So 2 points to draw from this. Quite apart from the emphasis again on facilitating the ease of compensation in very difficult situations from a victim's point of view, references to the guarantee funds and compensation bodies in the member states of residence providing the compensation, and more particularly, no mention of which compensation measure it is that is to be used in relation to these matters.
Well, doesn't it postulate that paragraph 2 on top of 481 a typical governing law?
Yes, that's in relation to, but bearing in mind that here the purpose of the proposal, and I didn't want to edit this, is obviously dealing with issues to do with the direct actions and the claim representatives and the information systems. And so in those cases, plainly that's right. But then when we get on to dealing with the systems that are specifically put in place where the direct action mechanisms don't work, which are the provisions that we are directly concerned with, we don't have specific indications of the applicable law. We don't have indications of what the level of compensation will be, and instead we have simply references to compensation.
But isn't the underlying thinking that this is to improve possibilities of recovery in respect of the basic loss, which you have incurred as a result of the negligent driver's fault?
Well, I think in your Lordship's question, the pivotal term may be basic loss, because what undoubtedly this is doing is saying that where you have suffered by reason of an accident overseas, you should be entitled to compensation. But if one assumes that the basic loss is the loss that would be awarded to you in the state where the accident occurred, then, of course, you are, in those circumstances, aligning the term basic loss with the approach that Mr. Mercer adopts. We say that what is going on here is the construction of a separate arrangement only to be used in the rare circumstances where there are unidentified drivers or uninsured drivers that cause these accidents overseas. And instead what is happening is that the directive is creating a mechanism that gives member states the ability to set the level of compensation in line with the domestic approach of a guarantee fund in the place of the victim's residence.
I appreciate that. Why would the European legislator have adopted that policy?
Why would it have adopted a policy of allowing...
Why wouldn't it just say all victims of motor accidents can recover damages from according to the local measure where they've of the country of their residence?
Well, because what we're talking about here is a structure being built whereby, under the legislation, whereby I suffer an accident in Greece, I come back to the UK, I want to be able to bring a claim against the compensation body in the UK. That compensation body has been created in the UK in order to enable me to get compensation. That compensation body is, as we'll see by reference to Article 7, to be providing compensation in accordance with Article 1.
I see that, but I mean, if suddenly there pops up the knowledge that in fact the driver's identity becomes available or his insurer's identity becomes available, then you lose all these benefits.
Well, if that comes to pass, obviously we've got Article 6 that's dealing with the dilatory insurer and the situation where no claims representatives put in place. And there what one has is a situation that is essentially trying to force insurers not to take advantage of the fact that they be situated overseas, making sure they have claims representatives. And so in those cases, where the insurer comes back on the scene, as it were, the compensation body drops out of the picture.
Yes, I mean, my question is basically why should those who are the victims of uninsured drivers have different and better remedies in terms of the amount they can recover, or sometimes worse remedies where UK law is less favourable than those in respect of whom there is an insurer? Because
what is being done is taking the approach of the guarantee fund in the UK. And the guarantee fund in the UK is, of course, only concerned with providing compensation in relation to accidents in the UK and providing assessments of quantum in relation to accidents in the UK under UK rules. And in those circumstances, what is happening is a European scheme is saying, you are entitled to bring a claim against this body, which is on the basis of it being the guarantee fund, of course, paying out in accordance with UK quantum. So you're not asking that body to do anything different from what it normally does in relation to cases. You're asking that guarantee fund approach to be applied by the compensation body, just as that guarantee fund would be applied in relation to domestic accidents. And of course, it is worth re-emphasising that the reason why the European scheme would create something different, something specific, that is using the existing approach of guarantee funds is because you are dealing with an injured party who's left with no recourse. And it's plainly easier for a UK resident who's likely to be in the UK to have a constructive engagement with the MIB, which is the relevantly designated body, about quantum on UK rules using local lawyers if necessary. I mean, it's just worth bearing in mind what the suggestion is that's being put forward by the MIB, that a victim should be coming along and in relation to the quantification of loss should effectively be putting forward argument on the basis of foreign approaches to quantum in circumstances where the MIB has no particular expertise in relation to Greek quantum or Bulgarian quantum or Italian quantum, because of course that's not the role it fulfills.
What's the position under Article 6 then? And it's the same, is it?
Yes, it's the same under Article 6.
So basically this is not just a situation of uninsured drivers, even when there's an insured driver and a foreign insurer on the scene.
Not on the scene, effectively.
Well, if there's a foreign insurer but they're not responsive,
yes,
then you get the higher damages.
Well, you get the
or
English,
the lower the English damages,
or UK
right?
damage,
Quite right. I get.
Yeah.
But the difficulty about that, our last argument you raised, is you accept that if a foreign insurer is on the scene, then the victim, the English victim, has to engage with the foreign measure of damages.
Of course, I have to accept that because that's what Article 6 recognises. There's no doubt about it. But what the UK government has done has looked at the directives, the scheme of the directives, and very clearly in Regulations 12 and 13 said, we create the compensation body as we're required to do, to deal with cases of overseas uninsured driver or unidentified vehicle accidents. And we say that that body is the MIB that deals with these cases on domestic quantum basis all the time. And we say that the UK body should provide the compensation on a UK basis. And they spell that out in the regulations. Now, Mr. Mercer was very careful to only take you through Regulation 13. I'll take you both to Regulation 12 and Regulation 13. But what is clear is that the UK government took a specific decision that was the appropriate way to implement these directives. And we say that was the appropriate way. It was certainly open to them to do so. And Mr. Mercer has to turn around and say, no, The directives mandate a different approach. So there are a range of reasons why you would do it. And the two questions are, has the UK done it? To which the answer is plainly yes. And does the European scheme prohibit that? To which we say the answer is plainly no. In circumstances where all the material that Mr. Mercer has taken you to merely refers to compensation. It does not refer to any specific measure of compensation, the specific measure of compensation in the place of the accident, or anything similar to that.
And supposing you're right, and then the MIB wants to recoup
Yes.
the amount it's paid out from a body elsewhere,
Yes.
what does it recoup? The whole of the amount it's paid, or
Yes.
it does?
Yes, which is why I said at the outset, in answer to my Lord's question about anomalies, we recognise that there is a degree of lumping it. That a Greek guarantee fund or compensation body may not want to have to pay back to the UK compensation body.
Is there any language you can point to which establishes that?
That establishes the lumping it.
Yeah, well, establishing the fact, your case, that the MIB can recover the whole of what it pays out, even though it's on an English basis, and is recovering it from a Greek outfit whose liability, if it was direct, would be less.
Well, it might be less. The point.
Well, it might be less.
Yes, I mean this is the point. I mean, it may well be that there is a degree of rough and smooth in relation to this, in relation to multiple cases. We accept that. But is there specific language identifying that? No. What the language does, as we can see, is it refers to a requirement for the payment of compensation by the compensation body, and then language of reimbursement from the foreign body. And we take that language of reimbursement not to be constrained by reference to some putative measure of the foreign body's compensation body, if it were compensating, which it's not, because the compensation body in the UK is doing it.
How do you get that from the agreement between compensation bodies and guarantee funds, which precedes the UK regulations? At any rate, I think it postdates the directives, or at least some of them.
I don't get it from there, my lord. I'm not trying to get it from that agreement. An agreement that's entered into between the guarantee funds and compensation bodies clearly can't dictate what the scope of the directives are. It's quite right, as Mr. Mercer says, that in relation to the fourth motor insurance directive, that agreement had to be entered into, but it doesn't dictate the terms and scope of the interpretation of the directive.
Doesn't it? They're presumably to be read together. They're both dated the 29th of April 2002. It seems inconceivable that they weren't being prepared in harness with one another.
The regulations and the agreement?
Am I wrong? I think I'm wrong
maybe
about
looking at a different set of regulations.
No, I'm wrong about that. You're quite right.
I'm sorry.
No, I'm wrong about that.
The essential point that's being made is that when you look at the provisions for reimbursement and the circumstances in which the liability arises in respect to foreign accidents at all,
yes,
it's plain, this is the argument, that the MIB is assuming a secondary liability, or what is in reality a secondary liability, which must be coextensive with the primary liability, namely that of the Greek compensating body.
that's being said against me.
But I mean, what is your answer to that? You say all this is accidental, and it was intended that the accident of the insurer not responding should, in principle, produce a different measure of damages that might be higher or lower. It doesn't. I mean, one looks when a submission is being made about legislation like this at some intelligent scheme, and all you have said so far is, well, there's an element of lumping it. But if there's a plausible alternative which doesn't involve lumping it, maybe that's the one should choose.
Well, as I'm going to show, one, there is an intelligible scheme, and second of all, any which way one looks at it, there is a degree of lumping it, even on Mr. Mercer's approach. Now, I think it might be sensible, just so that when we go back to the European law, you have the UK legislative scheme in mind, that actually we look at the UK scheme first, because that was something that Mr. Mercer dealt with rather briefly. And when one is suggesting that the draftsman of this scheme didn't have a sensible regime in mind, or that might be suggested, it's perhaps important to have regard to the terms of that scheme itself. It's at tab 20, tab 19 in bundle 2. Now, these are the 2003 regulations. Mr. Mercer said, well, when one comes to look at this, one must consider the interpretation in context. He's obviously emphasised various authorities which talk about looking at context and purpose rather than simply wording. I'm not for a moment suggesting that the interpretation of a statute of this sort shouldn't take into account either the context or the purpose. In terms of the context, the existence of the agreement is noted, albeit that that's an agreement between these various bodies and can't in and of itself dictate how either the directives or indeed this legislation should be interpreted.
Nobody's talking about dictation, but where is it noted, the existence of this agreement?
The existence of the agreement, I believe... So the agreement is, I'm not sure it's actually referred to specifically. That's in the directive. I'm sorry, I'm not sure whether your lordship's asking whether there's a reference in...
Yes, I was, because I thought you said there was.
No. I think that the reference to which Mr. Mercer drew the court's attention was in the directive itself. Yes. I'm sorry, not in this legislation. And I think, to be fair, what his point was that when you came to implement the fourth motor insurance directive, you needed to have had in place, these entities needed to have entered into this agreement. You can actually see that it's at page 346 in Authorities Bundle 1, relating to implementation. That's in the fourth motor insurance directive. I'm sorry, my lord.
No, thank you. That's helpful.
I think in relation to regulations itself, there isn't a mention.
Where do we find it on 346?
Down in implementation.
Oh, yes. Oh, yes, there we are. There's the agreement in accordance with Article 6.3.
Yes.
Yes.
I think that was the reference your lordship was perhaps looking
Yes, that's what I was looking for. Article 6, well, I think that's what you pointed to. Yeah.
Yes, I'm sorry, I wasn't meaning to say that there's actually a reference in the 2003 regulations, because I don't believe there is. Mr. Mercer prayed that agreement in aid, notwithstanding that it's not referred to in the 2003 regulations. I think when one comes to consider the context of these regulations, just two passing points to bear in mind. First of all, just the status of legal approach at that time in relation to questions of choice of law, just as a matter of context. Of course, it is under the rules in Hardy and Whelan's that the draftsman would have been considering, or the rules in Hardy and Whelan's would have applied to questions of choice of law in relation to damages claims at this time. In other words, that where one had an accident overseas, the substance of the claim...
Are you sure about that? I mean, Hardy and Whelan's wasn't decided till about 2006.
Yes, but I'm using that as shorthand, because Hardy and Whelan's, of course, there sets out that the approach being adopted as to the difference between substance and procedure meant that issues as to quantification fell within the scope of procedure, which was confirmed in Hardy and Whelan's. And so I was using that, I'm sorry, as a shorthand for these purposes. The only point I make is that is in contrast, of course, to the situation post-Rome II. So that's one piece of context that any draftsman would have in mind. And the other point that's just worth bearing in mind is that Mr. Mercer has rightly said that following a case of Odenbright in 2006, it was recognised that foreign insurers could be sued directly in the UK. Up until that point, I think there was at very least some doubt about that proposition. But that is just a little context. When we come on to the terms of the 2003 regulations, if I may, picking up interpretation, my Lord Toulson is already ahead of me in relation to the correction of compensation body, should be the reference to Regulation 10. Then if we turn over the page, there's two particular points to pick up. Guarantee fund means the Motor Insurers Bureau I leave to one side for the moment the issue of the definition of guarantee fund. Mr. Mercer suggests that there's some amendment in relation to it. In relation to the definition of injured party, I just note that it means a person resident in an EEA state claiming to be entitled to compensation in respect of any loss or injury resulting from an accident caused by or arising out of the use of a vehicle. So that's the definition that we've seen in the directives being adopted. And of course, there's no surprise in relation to that, or indeed in relation to a number of other definitions that are used here, because as Mr. Mercer rightly said, these regulations were being introduced in order to implement the Fourth Motor Insurance Directive, or relevant parts of it. There are other regulations that enact other relevant pieces. Now, Mr. Mercer indicated that regulations 3, 4, 5, 6, 7, 8 and 9 really deal with the information centre provisions, and the relevant provisions with which we're concerned are then the role of a compensation body in the United Kingdom. And if we start, we've seen Regulation 10, that the MIB is approved as the compensation body for the purposes of the Fourth Motor Insurance Directive. And that is footnoted down, see Article 6, and that, of course, is Article 6 of the Fourth Motor Insurance Directive. Then we come to Regulations 11 and 12. And this is the entitlement to compensation where the insurer is identified. So these regulations 11 and 12 are dealing with Article 6 of the directive and what's been referred to by Mr. Mercer as the dilatory insurer, or the insurer who fails to establish a claims representative. And you'll see at 11.1, this regulation and Regulation 12 apply in a case where the injured party is resident in the UK. That person claims to be entitled to compensation in respect of an accident occurring in an EEA state other than the UK, or a subscribing state, that doesn't matter for these purposes. And C, the loss or injury to which the claim relates has been caused by or arises out of the use of a vehicle which is normally based in an EEA state other than the UK, or is insured through an establishment in an EEA state other than the UK. So those are the predicate conditions. Where this regulation applies, the injured party may make a claim for compensation from the compensation body if he's not commenced legal proceedings against the insurer of the vehicle. So as Mr. Mercer indicated, if you've started suing foreign insurer, then you're not able to come and seek compensation from the compensation body. And either of the conditions set out in paragraph 3 is fulfilled. And these conditions are that the injured party has claimed compensation from the insurer of the vehicle or the insurer's claims representative, and neither the insurer nor the claims representative has provided a reasoned reply to the claim within the period of 3 months after the date it's made. This again reflects Article 6. and that the insurer has failed to appoint a claims representative in the UK, and the injured party has not claimed compensation directly from that insurer. And then we've got 12. Upon receipt of a claim for compensation...
Just pausing there, is there any hint of the basis upon which the compensation should be claimed?
In relation to that regulation, no. As we come on to 12, it's very clear.
Right.
But in relation to the claim against the foreign insurer, what basis could it be other than the tortious liability of the driver?
I don't think we take issue with the fact that if you're bringing a claim against a foreign insurer in relation to an accident in a foreign state, that the relevant claim would be under the principles of law of that foreign state.
Well, including quantum?
In relation to that claim, yes, it would be in relation to quantum as well. We recognise that.
Yes. So what you're saying is that the precondition for the operation of Regulation 12 is that in this context a claim for compensation quantified under Greek law has been made to the insurer of the wrongful driver, and there has been dilatory behaviour.
Yes.
But you say that opens the door to an English law claim against the MIB. I think that must be the logic of your...
Yes, that is absolutely right, and that's what Regulation 12 says.
That's what you're saying it says?
Yes, absolutely. So 12, response from the compensation...
Sorry, just one last question
I'm sorry,
on that.
my lord.
If you had such a claim which you were proceeding with at common law for damages, the quantum of the claim, other things being equal, would be on the basis of an English assessment, not a lex loci assessment.
Yes, at this time it would have been, absolutely, yeah. That's right. That was
so how do we guess that the quantum under Regulation 11 should be not on that basis, but on the basis of the foreign?
We don't need to guess, my lord, fortunately, because of the terms of Regulation 12.
Right. So we don't get out, we get out 11.
Yes, I'm sorry. The only reason I was going through Regulation 11, because it's properly the predicate of Regulation 12. And
yes, I appreciate that. I mean, you're relying on 12.4b.
I am.
Once you get your claim against the MIB.
Yes, that's precisely. You're well ahead of me, my lord, but I was just working my way through.
Certainly.
Yes. 12.1, upon receipt of the claim for compensation under Regulation 11, the compensation body shall immediately notify the insurer of the vehicle, the use of which is alleged to have caused the accident, and the foreign compensation body in the EEA state in which that insurer's establishment is situated, and, if known, the person who's alleged to have caused the accident. So the first stage, when the compensation body gets involved, is actually the compensation body trying to prompt these other potential, I'll refer to them as defendants for these purposes, saying that it has received a claim from the injured party and it responds to that claim within 2 months from the date on which the claim was received. The compensation body shall respond to a claim for compensation within 2 months of receiving the claim. So what 12.1 is doing is saying the compensation body will try and prompt these other persons, insurer, foreign compensation body, person alleged to have caused the accident, telling them that it's going to respond in 2 months. Then 12.2 is a requirement to respond within 2 months. And then if the injured party satisfies the compensation body as the matter specified in paragraph 4, now I haven't raised this with my learned friend, but I think this may actually be another typographical error and it should actually say 4A, but it matters not for the meaning here. Matter specified in paragraph 4, the compensation body shall indemnify the injured party in respect to the loss and damage described in paragraph 4b. So then we go to 12.4. The matters referred to in paragraph 3 are that a person whose liability for the use of the vehicle is insured by the insurer referred to in Regulation 11.1c is liable to the injured party in respect of the accident which is the subject of the claim. So that's the liability issue. And then 4b, the amount of loss and damage, including interest, that is properly recoverable in consequence of that accident by the injured party from that person under the laws applying in that part of the United Kingdom in which the injured party resided at the date of the accident. So in answer to my Lord Clerk's question, there's no guessing. We don't need to make any assumptions. It's spelled out here absolutely clearly. Now, I take the point that is raised by both my Lord Mance and my Lord Hodge, that in relation to this scheme is being put in place in circumstances where if the insurer comes back onto the scene, then the action then becomes an action between the claimant and the insurer. But there is no doubt that Parliament has specifically put in place a scheme here that says this compensation body that we are creating in implementation of the directives is to pay out compensation on a UK measure.
The Secretary of State, isn't it?
I'm sorry, yes.
Is there any... I mean, where did he or she get it from? Does paragraph 4 have any homologue in the directives?
No, as I've already indicated, what the directives don't do is they don't specify levels of compensation anywhere. There isn't that identification at all. I will come back to the directives, of course, but this is the approach that's being adopted quite explicitly in relation to dilatory insurer cases.
This is supposed to implement Article 6 of the Fourth Directive.
Yes, absolutely.
What is the answer to the point that you may have a country of accident whose law would give you a more generous remedy than the UK, and that 12(4)(b) is therefore mandating a lower rate than the injured party is entitled to under Article 6 of the Fourth Directive. Therefore, his EU rights are not properly reflected.
Well, the first answer to that is that Article 6 is not mandating compensation at the level of, for example, the principles of quantum under the place of accident. And therefore, if Article 6 isn't mandating a particular level of quantum, there is no breach of European law, no putative breach of European law, if a measure of quantum is built into the regulatory structure that the UK has put in place. So that is why there is no issue there, because what one sees in relation to Article 6 is reference to compensation, but not a particular level of compensation.
Well, yes, I mean, would that comply with the European principles of equivalence and effectiveness, looking at the scheme as a whole and its general thrust?
We say yes. We say yes, absolutely, because, of course, it goes without saying that if you thought you'd be much better off going against a Greek guarantee fund directly, then, as I indicated in my response to my Lord Sumption, you could still do that. But what this is doing is facilitating you, as in this case, a UK resident, bringing an action against a UK body who has the expertise and knowledge of paying out in relation to UK quantum, that you can come and much more easily get compensation. So there's no putative breach of European law, and there's no conflict with the directives, which is why the Secretary of State was able to enact this legislation.
So just tell me, under which provision, you say you could always go against, obviously if there was a Greek insurer, you could go against the Greek insurer. Is there any basis on which you could go against the Greek compensation body direct?
You think you can go against the Greek guarantee fund?
Under what would that be?
That will be under the second directive.
And if it were a French motor car being driven in Greece, against whom could the claimant, against which fund could the claimant go?
Well, this is where matters become potentially more interesting, because, of course, Mr. Mercer emphasised very heavily in relation to the second motor insurance directive how Article 1.4 was all about being able to bring your claim against the guarantee fund of the place of accident. But actually, what we see is a scheme which enables you to bring your claims putatively against the place of the scheme of accident, the guarantee fund of the scheme of accident. But as we'll come on to see in relation to Article 7, the reimbursement process here is rather more complicated. And so, albeit that you would have claims elsewhere, actually this is the example that creates a degree of lumpiness under Mr. Mercer's own account as well.
Yeah, but I mean, what's the short answer? You know it's a French car, but you haven't got the full number plate, so it can't be identified.
Yes.
To what fund can the claimant have recourse?
Well, under the second directive, each member state has to set up or authorise a body with the task of providing compensation, at least up to the limits of the insurance obligation, for damage to property or personal injuries caused by an unidentified vehicle or a vehicle for which the insurance obligation provided in paragraph 1 hasn't been satisfied. That, of course, is concerned with the insurance obligation specified in Article 1.1, which refers back to the insurance obligation in Article 3.1 of the first directive. So in those circumstances, my understanding is that Mr. Mercer would maintain you could bring a claim against the Greek guarantee fund as being the place of the accident. And a question also arises whether you can bring the claim against the French guarantee fund as the body that is supposed to stand behind the vehicle that is normally based in its territory, France.
Now, you say that's Mr. Mercer's answer. What's your answer?
In relation to those, we believe that both of those potential claims are available. In addition, of course, to the compensation body claim, if the requirements of 11 and 12, or indeed Regulation 13 are met, which is why, in fact, this scheme is rather more complicated than the approach articulated by Mr. Mercer suggested. And I'll come back to that point about reimbursement, where you've got a French car causing an accident in Greece involving a UK citizen, because that's the situation where you end up with the suggestion on Mr. Mercer's account that you have a Greek level of compensation that can be claimed against a UK body that then seeks reimbursement of a Greek level of compensation from a French guarantee fund. And in those circumstances, you do create a great deal of inevitable complexity, but it's one of the further anomalies that exist in the system.
Well, is that an anomaly? I mean, it's simply the result of focusing on the measure of damages at the place of the accident, isn't it?
Well, yes, but the story that Mr. Mercer told was you focus on the damages at the place of accident under the law of the place of accident. Then, on his story, the UK compensation body pays out on that basis. And then he was saying, well, the ultimate debtor will end up being the Greek guarantee fund. But of course, that's not true in certain cases, and in particular in the case where it's a French driver, a French car, because in those circumstances you end up with a situation of a claim for Greek level of compensation being reimbursed by a French entity, not by the Greek guarantee fund in circumstances...
Yes, I mean, he said that. He said that. I've got a note of it. So that I don't think you're...
But we say that doesn't fit with the account that he's giving, that everything circles back to the place where the ultimate debtor is effectively paying debts under the law that governs them as a guarantee fund. In any event, if I may, I'll go back to the regulations, because I was just dealing with Regulation 12. Then we've got 12.5. This is just picking up the point I've already mentioned. Compensation body shall cease forthwith to act in respect of a claim as soon as it becomes aware that the insurer or the claims representative of that or insurer has made a reasoned response or the injured parties commence proceedings. Then we have Regulation 13. So Regulation 13, as was already
So in those circumstances, the entire claim is then against the insurer, is it?
I think that would be being assumed there, yes. Whether or not there could be other parties, I'm not sure whether that's being. I don't think that's being ruled out in those circumstances. But in order to govern whether or not the compensation body claim proceeds, it's undoubtedly the insurer or the claims representative that's the relevant trigger. Which, of
If
course,
the insurer says I'm not liable, then what?
The insurer says, I'm not liable.
For some reason.
Well, that would be a reasoned response that is required under the terms of Article 6. And so at that point, the engagement with the insurer would still be on foot. But that is, the scheme under Article 6 is not ruling out the possibility of an insurer taking issue with liability as well as with levels of quantum. So then if we move to Regulation 13, entitlement to compensation where vehicle or insurer is not identified. So here we have the situation where the regulation applies where an accident's caused by or arising out of the use of a vehicle which is normally based in an EEA state, occurs on the territory of an EEA state other than the United Kingdom, again leave aside subscribing state, and an injured party resides in the United Kingdom. So this is an accident overseas involving a vehicle that's normally based in an EEA state injuring a UK resident, and then that injured party's made a request for information under 9.2, so that's trying to find out about vehicle and insurer. And it's proved impossible to identify the vehicle, the use of which is alleged to have been responsible for the accident, or within a period of 2 months after the date of the request, to identify an insurance undertaking which insures the use of the vehicle. And then it says, where this regulation applies, the injured party may make a claim for compensation from the compensation body. So this is effectively mirroring the process that occurs in relation to the dilatory insurers, albeit it's more curtailed because if you don't get the information you need under Regulation 9.2, you've got no further engagement with other potential defendants. So you bring a claim for compensation from the compensation body, and then it said the compensation body shall compensate the injured party in accordance with the provisions of Article 1 of the Second Motor Insurance Directive, as if it were, so as if the compensation body were the body authorised under paragraph 4 of that article and the accident had occurred in Great Britain. Now, the straightforward reading of that paragraph is essentially to mirror the approach that's adopted in relation to Regulation 12. Because what we know is that Article 1, paragraph 4 of the second directive is the paragraph that we've seen that requires each member state to set up a guarantee fund in its state to provide compensation up to at least up to the limits of insurance obligation for damage to property or personal injuries caused by an unidentified vehicle or a vehicle for which the insurance obligation provided for in paragraph 1 has not been satisfied. And as was noted as Mr. Mercer was going through, that provision also makes clear that each member state shall apply its laws, regulations and administrative provisions to the payment of compensation by this body. So what we know is that the body created under Article 1.4 of the Second Motor Insurance Directive is the guarantee fund that is dealing with domestic accidents involving unidentified or uninsured vehicles.
The reason why it's referring to the two deemings, as if the body were authorised under paragraph 4 and as if the accident had occurred in Great Britain, is that it refers back to Article 1 of the second directive, and therefore it's required to because of that drafting technique, it is basically adapting Article 1 of the second directive to a situation where the accident has occurred abroad. If they wanted to replicate the effect of subparagraph 4b of paragraph 12, why didn't they just do it?
Well, the answer to that is not one that I can provide. But your lordship, though articulating why it is that there is a need for a deeming provision, quite rightly, in relation to the link back to Article 1.4, is then making an implicit assumption that we don't accept, that in referring back to Article 1.4, what 2B is doing is designating the compensation body in the UK as the Greek guarantee fund. And we say that is not the proper reading of it. The reason I surmise why the drafting technique is as it is because, of course, of Article 7 itself. Because Article 7 itself of the fourth directive says compensation shall be provided in accordance with the provisions of Article 1 of the second motor insurance directive. So what the draftsman has done is taken that approach, but we say very clearly is saying what you do is you treat the compensation body as being like the guarantee fund. Which guarantee fund are you talking about? You're talking about the guarantee fund as if the body had been authorised under paragraph 4 of that article, and we say that must mean authorised in the United Kingdom. It can't mean authorised anywhere in the EU. For the
Why not? Surely the second directive is dealing with situations where the insurance obligation hasn't been satisfied in the state. By definition, we're talking about a situation where it hasn't been satisfied in Greece, because you haven't identified a Greek insurer, and therefore the UK Motor Insurance Bureau is being treated as if it were the Greek body authorised under paragraph 4, and the accident has occurred in Great Britain. So
yes,
why doesn't that work?
Well, two reasons. One, when we're talking about authorisation or deemed authorisation under domestic statute, the natural interpretation is that the authorisation is for the purposes of the UK.
No, because Article 1.4 of the second directive uses the word authorised. It says each member shall set up or authorise a body with the task of providing compensation. So it's perfectly capable of referring to the Greek Motor Insurers Bureau.
If it was referring to the English or British
Yes.
Motor Insurance Bureau, it would be completely redundant. All it would be achieving would be to identify MIB as the relevant entity for the purposes of paragraph 4, something which is already achieved in the second directive and in paragraph 10 of this one, of these regulations.
No, because what is being said here is that the compensation body shall compensate as if it were the guarantee fund authorised. And it's not saying authorise any guarantee fund, it's saying that it is a guarantee fund that would be authorised in the UK, we say. And just to reinforce that, and the accident had occurred in Great Britain. Because, of course, guarantee funds under 1.4 are concerned with accidents in their own member states.
Well, you say that, and that's a question I asked Mr. Mercer about, and I think he may have said the same. But I'm not entirely sure why, because Article 1.4 is requiring each country to set up a motor insurance bureau which satisfies the insurance obligations required under the first directive. And those insurance obligations are to insure yourself or to have a scheme of insurance, not only in respect of accidents in your own country, but also in respect of accidents in another EU country. Look at Article 3.2 of the first directive. So that, it seems to me, it's Article 3.2, which is it? It's Article, I think it's Article 3.2.
I'm sorry.
Each member state shall take all appropriate measures to ensure that the contract of insurance also covers, according to the law in force in other member states, any loss of injury caused in the territory of those states. So,
yes, I understand your Lordship's point by referring to Article 3.2 of the first directive, but I think it is important to look at exactly what it is that the Article 1.4 second directive obligation is concerned with. Article 1.4 says each member state shall set up or authorise a body with the task of providing compensation at least up to the limits of the insurance obligation for damage to property and so on, for which the obligation provided for in paragraph 1 has not been satisfied. Paragraph 1 is Article 1, paragraph 1, the insurance referred to in Article 3.1
I see. So it's
of the first directive. So it is specifically not covering 3.2, which is why on this, Mr. Mercer and I think, are in agreement.
yeah. So one comes back.
Yes, so then we travel back to the terms of Regulation 13, and this is the reason why I say it's speaking about treating a compensation body as if it's a guarantee fund. Which guarantee fund? It's the UK guarantee fund, and the accidents occurred in Great Britain, and those words would make no sense if you were talking about the Greek guarantee fund or the Italian guarantee fund. So, in answer to my Lord Sumption's question, could this have been drafted better? Could it?
That wasn't my question. It might be very interesting.
Well, almost anything could be
Yes, I'm sorry, though.
drafted better.
Quite properly. Yeah, could language akin to 4A and 4B have been used? Yes, it could, but one can understand why the draftsman tried to take the language of Article 7 itself. Is it achieving in relation to levels of compensation the same thing as 4B in 12? Plainly it is. And the interpretation of those words do not support any other meaning. It cannot be read as suggesting that in fact it's the Greek guarantee fund that's being covered here. And Mr. Mercer, although he referred to Lord Justice Moore-Bick's interpretation and said it came some of the way but not most of the way, and Lord Justice Moore-Bick referred to the words having a series of deeming provisions, the clear reading of these provisions is that what 13.2b is doing is effectively providing, in the circumstances of the fact of this litigation, perhaps an unhelpful shorthand, but a shorthand nonetheless, of 12.4b in relation to compensation. And if you do not read it in that way, you do not make sense of the words of that provision. And it is obviously for that reason that Mr. Mercer strives so hard to say that there is a mandatory scheme under the directives that requires you to treat the relevant guarantee fund as being the Greek guarantee fund.
Well, I just wonder about that, because the explanatory notes confirm what one might expect anyway, they're not.
Which page is this?
Explanatory note, MS 652.
Thanks.
That paragraph 2 of that note, these regulations give effect to Articles 5, 6 and 7.
Yes.
And therefore we may proceed safely on the basis that's what Regulation 13 is aimed at. It's aimed at implementation of Article 7.
I entirely concur.
Right. That being so, can one not read the rather unsatisfactory language of 13.2b as simply saying that they're to compensate in accordance with provisions of Article 1 of the second directive as if this were a paragraph 4 type of case. And there are the two limbs to make that applicable. One has to do with who is the authorised body, and the other has to do with location. But all this is really saying is well, you extend Article 1 of the second Motor Insurance Directive to this situation and so give effect to Article 7?
Well, the answer to that is no, if the conclusion of that analysis is that it's the Greek body that should be treated as the authorised body here, because it's very difficult to understand why it is, A, that what's being said in relation to a UK body here, in other words, the compensation body, is that it should take on the colour of whichever guarantee fund it is where the accident occurs, because that's what's being said. It's not a single authorisation. It's saying you take on the colour of whichever is the possible authorised guarantee fund of the place of accident. And the second is that where it's specifically saying in the accident had occurred in Great Britain, it's incredibly hard to understand how those words should have any meaning in the sort of generalised interpretation which your lordship is putting forward.
Well, I'm putting it forward only on the premise that, which you've accepted, that one way or another this is intended to implement Article 7.
Yes. Well, as I say...
And once you've got that foundation, if the language is infelicitous, you may have to treat it in a way that you wouldn't if you were just construing a primary document entered into without a background.
Well, of course, there are 2 points to make. We recognise that under terms of mar leasing in particular, a strained interpretation of domestic statutory language is acceptable. Yeah. We say this would not be straining the language, this would be breaking the language in these circumstances. But there's a broader point here, which is that that approach is predicated on the idea that Article 7 of the directive is itself specifying that it must be the Greek Guarantee Fund. And we say that's not right.
Yeah, and obviously, if you torpedo Mr. Mercer on Article 7, then your path is very much easier.
Yes, well, torpedoing I wouldn't want to do in relation to Mr. Mercer. That would be totally inappropriate. But nonetheless, I think all I need to do is make out that Mr. Mercer's interpretation of the directives is not a mandatory approach to the specification of the guarantee fund in relation to Article 7. And that's what I do say is the position, and that's why there was room for the Secretary of State to implement as he or she did.
Well, if Article 7 isn't Act Clear, then we have for a reference, don't we?
Well, no, we say that it could be. We say that it could be. It may not be Act Clear in the sense of it is unclear whether or not it mandates the identification of the UK Guarantee Fund or leaves the member states room to decide. All that this court has to decide is that Article 7 does not mandate the specification of the Greek Guarantee Fund. And it would only be...
We would have to be certain about that.
Yes, you'd have to be certain about that, but you could be unsure about the remainder. If you are unsure about that, I quite accept that that would be the circumstance in which a reference would be appropriate. I can't avoid anything other than that conclusion. But it doesn't mean that one has to conclude that all aspects of Article 7 are Act Clear. I think that's the proposition I would put forward in those circumstances. I think the other point before I leave the regulations is that whilst Mr. Mercer endeavoured entirely to keep these two provisions separate, when it comes back to my lord's what might be called strained interpretation of Article 13, Regulation 13.2b, it is important to bear in mind that what has been done in 12.4b is make provision for compensation in accordance with domestic rules to apply even in those circumstances where the insurer could step back in. And therefore, when you are looking at this package of measures together, which is a compensation body being established, and as we saw from the travaux préparatoires, the compensation body being used for both of these purposes in the final directive, to say that in relation to regulations in 11 and 12, where it's clearly spelled out, it's right that the compensation body should be compensating at a domestic measure or in accordance with domestic rules. But in relation to 13, where there's no prospect of the insurer stepping back in or no realistic prospect, it should be going back to a foreign measure of compensation would be a further straining of the relevant interpretation of these regulations. So we do say that one does need to read them as a whole. And as I say, going back to the overall context, it's not necessarily hugely surprising that a draftsman might look at these things in this way in circumstances where the backdrop was the Hardy and Whelans or pre-Hardy and Whelans approach in common law, and that may have conditioned the way that these things were thought about. So I don't want to spend further time in relation to the regulations. There are one or two further points, if I may, I'll go back to and just pick up in relation to the European law, because the proposition that I face is that Article 7 is mandating the use of the Greek Guarantee Fund measure of compensation. I refer to the Greek Guarantee Fund as a shorthand always because of this case. Obviously, it's the guarantee fund of the place of accident, as Mr. Mercer put it in his submissions, depending on where the accident might be. Now, in relation to that, I've taken you to certain of the relevant travaux préparatoires. Mr. Mercer has taken you to other passages in the travaux préparatoires. What one doesn't see in any of that material, as I say, is specification of a level of compensation. When one looks at the definitions upon which he placed weight, so starting right back with the first motor insurance directive, we see the definition, obviously in Article 1 of injured party, is an injured party being a person entitled to compensation in respect of loss or injury caused by vehicles. And as I say, the simple fact of entitlement to compensation doesn't tell you what the relevant level of compensation is. That approach is, of course, then carried forward into the second motor insurance directive, where we've already traversed Article 1 to some degree. The provisions of the second motor insurance directive are spelling out, in essence, the extent of the insurance obligation, and also setting up these guarantee funds that deal with domestic accidents. And as I say, and we emphasize that when one refers to a guarantee fund, one is always, in this context, talking about the body that recompenses for domestic accidents and inevitably, therefore, under domestic levels of compensation. And we do say that that matters when one comes on to consideration of references to guarantee funds in the fourth motor insurance directive. But again, we're not seeing here any reference to a level of compensation because by reference to any particular law, because, of course, in relation to the first, second, and third directives, we are, by their nature, certainly in relation to the guarantee fund, for the reasons I've articulated, only talking about domestic measures. Then when we come on to the fourth motor insurance directive, the relevant travaux that Mr. Mercer referred you to, he obviously picked on the the recitals at 8, 16, 25, 28 through to 31, what we note when we read those again is that what is being talked about is the need for the creation of a compensation body. In particular, in 25, it's necessary to make provision for a compensation body to which the injured party may apply, where the insurance undertakings fail to appoint a representative or is manifestly dilatory in settling a claim, or where the insurance undertaking can't be identified to guarantee that the injured party will not remain without the compensation to which he's entitled.
Sorry, which page are you on?
I'm so sorry, 341.
341.
I apologise.
No, thank you.
Your Lordship may already have marked this, Mr. Mercer's already taken.
Yeah.
The intervention of the compensation body should be limited to rare individual cases where the insurance undertaking has failed to comply with its duties in spite of the dissuasive effect of the potential imposition of penalties. So it's envisaged that these will not be the common garden run-of-the-mill type situations. But again, it's not specifying how a compensation body set up in a particular member state should adopt an approach by reference to compensation measures made in relation to foreign member states.
Can I ask this question? I mean, once the Rome regulations come into force in or about 2007, there can be no question inside Europe of differing proper laws of the tort. Now, at any rate, at that point, don't we have to read these directives against a European background, which now provides that the starting point of entitlement of an injured party is going to be that such entitlement is measured by the law of the place of the accident, barring one of the exceptional cases, which this isn't.
The answer is no, my lord, for two reasons. First of all, because, as I'll come on to explain, Rome 2 doesn't bite in relation to these.
But it does bite in relation to the underlying what is being compensated here. I mean, these are mechanisms for meeting a liability which primarily rests on the tortfeasor, the negligent driver, and these are convenient mechanisms which, no doubt, after Brexit, we will have to think about recreating. But they are convenient mechanisms which give all sorts of ancillary or parasitical rights designed to assist EU citizens. Why don't you read the regulations in that light once Rome 7 comes in at any rate?
Well, as I say, the first reason is in relation to the matters with which we're concerned, which are these compensation matters. Rome 2 doesn't, as I say, apply. So in relation to the issues with which we are concerned, and the question with which we are concerned is whether or not there's a specification of a level of compensation in relation to a compensation body, then we say Rome 2 doesn't apply, it doesn't make any difference. The second thing that I think is perhaps instructive in this regard is, as Mr. Mercer has indicated, what happened was that the 6th directive, of course, simply accumulated the 1st to 5th directives, but made no changes at all in relation to these matters. That codification or consolidation was, of course, undertaken after Rome 2. So in those circumstances, to suggest that actually there are differing meanings to terms that have subsisted over substantial periods of time, we would say would not be the right approach in relation to these matters. And the other issue that I think we will come on to when we look at Rome 2 itself is, although my learned friend has put forward...
Isn't it, that's a slightly archaeological approach to the 6th directive, and I agree we haven't been looking at it. We have been indulging in archaeology, but I thought the purpose of codification actually was to look at the codified version as the law, as the relevant law, and as you point out, it is in a situation when the Rome 2 regulation had already been enacted.
Yes, of course. But as Mr. Mercer has quite fairly and properly done, he has worked his way through the first, second and fourth directives.
Right.
It is no part of his case, whilst he has two cases, one on interpretation, one on Rome 2, it's no part of his interpretation case, as I understand it, that the meaning of directives 1, 2 and 4 has changed since Rome 2. His case is it has been thus since they were enacted, and that when it comes to interpreting the regulations, it's no part of his case in relation to those that he said on his first argument that somehow the regulations were lawful on the interpretation pre-Rome 2, but not subsequently.
It is a bit odd that the 2003 regulations seem to have been made in ignorance of the fact that there was now a codified EU regulation, EU directive, but that's, I suppose, just betrays a certain level of ignorance on the part of the drafter.
No, it postdated the regulations
Did
as
it?
well.
I thought it...
2009, I think.
Yes,
was
yes.
The sixth directive.
Oh, well, then
2009, yeah.
I apologise.
Yes.
No.
But it's right. Okay, thanks.
No.
So you were just on the recital.
Yes, I'm sorry, my lord. The other point I'll come back to on Rome 2 is that Rome 2 does actually create the possibility in all sorts of situations that different laws can be applying because of the various escape clauses and exceptions and so on. And in those circumstances, then to try and read down these general provisions, I think would be much more complicated, which is perhaps why Mr. Mercer hasn't gone in that direction. Sorry, I was just referring briefly to the recitals on the fourth Motor Insurance Directive. I was highlighting 25 merely as talking about the creation of this domestic compensation body. Then we've got, then he highlighted 28, the compensation body should have the right of subrogation insofar as it's compensated the injured party in order to facilitate the enforcing of the compensation body's claim against the insurance undertaking where it's failed to appoint a claims representative or is manifestly dilatory. And again, we don't see, and I think it was pointed out that there's a comma missing in the following part. The body providing compensation in the injured party state should enjoy an automatic right of reimbursement with subrogation to the rights of the injured party on the part of the corresponding body in the state where the insurance undertaking is established. The latter body is best placed to institute proceedings for recourse against the insurance undertaking. Now, this is all part of Mr. Mercer's story that says it's a seamless process. One applies the law of the place of the accident through the medium of the rules applying to the guarantee fund of the state of the accident. The UK compensation body applies that foreign guarantee fund approach. The compensation body then has the right of subrogation back to the foreign guarantee fund itself.
I mean, I suppose we're talking about the law of the place of the accident, but the argument or the submission could be put slightly differently. You apply whatever is the proper law of the relevant tort. I mean, if I injure my family while I'm driving in Greece, it may be that English law would apply rather than Greek law then.
Well, yes. I mean, there are a range of issues that arise because although Mr. Mercer rather smoothly moved from his first argument on interpretation to his second argument on Rome 2, his first argument on interpretation is actually to say that the approach of the compensation body should be the approach adopted by the foreign guarantee fund. Now, that is different from adopting the law of the tort of the place of the accident, because those two things can be different, because this is actually an issue that's come up in the other case of Howe that's referred to in the papers. Because in Howe, there's a question whether or not the relevant limitation period is that which applies to the French guarantee fund or just under ordinary French tort law, and they're very different. And so one needs to be careful that one is actually delineating the two. So Mr. Mercer's interpretation argument isn't actually an argument about applying the law of the tort of the place of the accident or indeed any other proper law. He's saying you apply the rules of the foreign guarantee fund.
Well, no doubt he can confirm that. I wasn't sure that that was what he was saying.
I think Mr. Mercer confirmed.
What's more, it's the final words, the closing words of 1.4. That's where the guarantee fund is told to apply its own rules, which is something that, I mean, even after Rome II is subject to specific rules given in community instruments.
So the final words of
1.4 in the second directive.
Yes. Oh yes, I see. Yeah.
So I'm sorry, my lord, but whilst I can see the temptation to conflate the two, in fact there is a material difference. And certainly there can be material differences in other cases, and we actually have a case that's live in relation to that. So again, the point I make here...
That one which has already been to the Court of Appeal?
Yes, I think. No.
Do we have it somewhere? Do we have that?
Tells me that it's subject to a permission application to go to the Court of Appeal, but we do have how, in first instance, in the bundles. I'll provide you with.
So it hasn't been to the Court of Appeal yet?
No, it hasn't been to the Court of Appeal.
Volume 336.
I'm most grateful to my lord.
Now,
I wasn't intending to go to it.
Well, you've got a few more minutes. I think you're probably doing quite well, aren't you?
Yes, I don't think there's going to be a difficulty on time.
But just carry on anyway.
Sorry, I was on recital 28 and simply emphasising there that even in relation to these subrogation mechanisms, there's no specification of the measure of compensation in respect of which the subrogation rights exist. Then we have 29. Even though the member states may provide that the claim against the compensation body may be subsidiary, the injured person should not be obliged to present his claim to the person responsible for the accident before presenting it to the compensation body. In this case, the injured party should be in at least the same position as in the case of a claim against the guarantee fund under 1.4 of the directive. And we say, well, you're talking about a compensation body here in a member state. We say you're talking about the guarantee fund in the same member state. You're not talking about a compensation body in one member state and a guarantee fund in a completely different member state. Certainly, for Mr. Mercer, who has to say it has to be the guarantee fund in another member state, that recital doesn't get him anywhere close to his contention. This system can be made to function by means of an agreement between the compensation bodies. We entirely accept that, but equally, we say that the agreements made between the compensation bodies do not, in the circumstances, tell us what the scope of the directive is and whether or not the approach adopted by the Secretary of State in making the regulations was contrary to the directives and impermissible. And then we have in 31, where it's impossible to identify the insurer of the vehicle, provision should be made so that the ultimate debtor, in respect to the damages to be paid to the injured parties, the guarantee fund provided for in Article 1.4, situated in the member state where the non-insured vehicle, the use of which has caused the accident, is normally based, where it's impossible to identify the vehicle, provision must be made so the ultimate debtor is the guarantee fund provided for in 1.4, situated in the member state in which the accident occurred. So there, when the specification of ultimate debtor is being provided for, there is a specification of which member state you're talking about, which guarantee fund you're talking about. Now, again, it doesn't talk about what the ultimate debt is, but it does specify that it is the guarantee fund in the particular member state, either where the non-insured vehicle was normally based in relation to uninsured cases or in relation to unidentified vehicles in the place of the accident occurring. Would that be a convenient moment?
Well, we'll resume at 10:30. Thank you very much indeed. Look forward to hearing your further submissions there.